Great to see you back still in such numbers. And we're going to resume our discussions now on section 2, following which, as I said yesterday, we will move to section 4, and then we will take up section 3 after that. So just a quick reminder for the interpreters, if you have a statement that you can send for the interpreters, please remember to do it before you speak. And also a reminder that we are waiting for your submissions as soon as possible. So thank you very much. We're going to pick up the speakers list we had yesterday and where we left off yesterday, and we'll move ahead now, and I will give the floor to the United Kingdom, to be followed by Israel. So United Kingdom, you have the floor now.
Thank you, Mr. Chair. The UK agrees with the importance of this section and emphasises the need to properly and accurately reflect the legal framework as a core basis for the regulation of armed conflict. We note and support the US's comments in this regard, and we have, however, we have a small point to make on paragraph 2.1, and we hope that our drafting will improve its accuracy and strength. Paragraph 2.1 currently refers to the obligations and commitments in IHL and international human rights law, and refers to the obligation to hold accountable. The UK would like to clarify that there isn't a general obligation in international law to hold accountable those responsible for violations. And this is a matter of some discussion in the international law community. There is, of course, a clear recognition of obligations in respect to one's own forces and those within one's jurisdiction. However, it isn't right to suggest that that the importance of accountability ends just there. Holding to account those who breach IHL is extremely important and something that can tangibly improve the protection of civilians. But clarity is sought over whether this refers to an existing specific obligation or intends to suggest that there is a general obligation. The UK would point out that the general obligation would be extremely difficult to put into practice. We therefore suggest the following drafting would be more fitting to a political declaration while emphasising the importance of this point. So we would suggest replacing the words including our obligation to hold accountable with and reiterate the necessity of holding to account those. So the full paragraph would read, we reaffirm our obligations and commitments under applicable international law, including international humanitarian law and international human rights law, and reiterate the necessity of holding to account those responsible for violations and our commitment to end impunity. Paragraph finishes. The UK would like to also comment on the suggestion made yesterday afternoon that the section, this section, section 2, refers to wording that includes reference to international human rights law specifically. The UK agrees that international human rights law applies in the context of armed conflict. It is important that any text on this point, however, properly and accurately recognises the interaction between IHL obligations and international human rights law obligations, noting that international humanitarian law has a lex specialis role in relation to international human rights law and in the context of the application of human rights and the related concepts in armed conflict. Thank you, Mr. Chair.
Thank you very much. I'm going to give the floor now to Israel, to be followed by the ICRC. Israel, you have the floor.
Thank you, Ambassador, and good morning. We have a few comments on section 2 regarding paragraph 2.1. The issue of applicability of international human rights law during armed conflict is a controversial matter which attracts divergent views. To avoid this controversy, and in order to make the text more inclusive, we support deleting the explicit reference to IHRL and replacing it with wording all other applicable international law, which is a more general articulation. Regarding 2.3, we suggest replacing the newly inserted text that reads to direct operations only against military objectives with the more precise and clear text of Article 52.1 of AP1, which would read that civilian objects shall not be the object of attack. Furthermore, we suggest changing the beginning of the last sentence in the text as follows. We also recall the obligations under international humanitarian law concerning the general protection of civilians, and so on, instead of the obligation under IHL to provide civilians with general protection. This sentence seems to be based upon Article 51.1 of Additional Protocol 1. However, it exceeds the article's original language in two significant ways. First, the obligation under Article 51.1 is not characterized in a general and sweeping manner, as suggested here, but as an obligation that receives its content only from its subsequent paragraphs. This is the full wording of Article 51.1, and I quote, "The civilian population and the individual civilians shall enjoy general protection against dangers arising from military operations. To give effect to this protection, the following rules, which are additional to other applicable rules of international law, shall be observed in all circumstances." End of quote. And then it goes on to list certain obligations. This is also the common way to understand Article 51.1. Secondly, while the articulation here implies a positive obligation, provide, Article 51.1 is phrased in a different manner. To correct these problems, the sentence should refer to Article 51.1 rather than rephrasing it as it currently does. And finally, as we stated yesterday, we believe it is important to clearly express explosive weapons are not prohibited per se under IHL, and therefore we support the addition of paragraph 2.4 bis that was suggested yesterday by the US delegation. Thank you, Ambassador.
Thank you very much. I give the floor next to the ICRC to be followed by Austria. So ICRC, you have the floor now.
Thank you very much, Mr. Chair. The ICRC welcomed the strong reaffirmation of international humanitarian law obligation in Section 2. IHL provides critical legal protections to civilians during armed conflict, including against the use of explosive weapons in populated areas. As we already mentioned yesterday, in our view, to achieve its purpose, this political declaration cannot limit itself to solely repeat existing legal obligation. But this does not diminish in any way the importance for the declarations to recall the limits imposed by existing international law. This is critical in our view because if properly interpreted and applied, IHL rules on the conduct of hostility will offer strong protection to civilians. In particular, every instance of use of explosive weapons must comply with the rule regulating the conduct of hostility, and this is a real challenge when using them in populated areas due to the high likelihood of indiscriminate effects. In many situations, indeed, the use of heavy explosive weapons against military objectives located in populated areas will be prohibited by the prohibition against indiscriminate attack, the prohibition against disproportionate attack, or the obligation to take all feasible precautions in attack, which must all be respected for an attack to be lawful. We believe that Section 2 in the revised draft appropriately recalls the central role of international humanitarian law. For this reason, and to support the Chair into advancing towards the finalization of the political declaration, the ICRC had not submitted any comments on this section. Allow me, however, to react to several of the suggestions made yesterday and this morning. In short, we support most, but not all, of the proposal made with regard to paragraph 2.1 and 2.4, and we will recommend retaining most of the current language in all other paragraphs and not include the suggested new paragraph, or at least not as in the proposed language. Let me go through this in more detail, and apologies in advance for being a bit long, or if I misunderstood some of the proposals made yesterday or this morning. So there were several proposals to strengthen paragraph 2.1, notably in terms of reaffirming the importance of complying with international law, condemning IHL violation by states and non-state parties to armed conflict, reaffirming the obligation to hold accountable those responsible and end impunity, that was yesterday, and the duty to investigate. And there was also a proposal to better distinguish law and commitments, and those are all welcome suggestions from our perspective. With regard to the two proposals made this morning to change this paragraph, to amend this paragraph, we would recommend retaining the current language, which is more specific with regard to international humanitarian law, as has been reminded. That is usually the accepted view that it does apply. And with regard to holding accountable, while hearing what the delegation mentioned this morning, the language suggested would be would fall under the requirement of international humanitarian law when there is an obligation to hold accountable for grave breaches. So in the legal section, we would recommend that the notion that this is an obligation is retained. With regard to paragraph 2.2, at the end of the paragraph, there have been suggestions to replace when conducting hostilities with when carrying out their operational requirements. We would recommend retaining the current language or alternatively referring to when conducting military operations. Both concepts, I mean, when conducting hostilities or when conducting military operations, are widely used in treaties, in customary international law, and other multilateral texts, which is not the case of the notion of operational requirements. Several amendments were proposed on paragraph 2.3, and we're actually concerned by most of them, but we also have a suggestion. So we would recommend against changing the wording precaution against the effects of attack to precaution when subject to attack. First, precaution against the effects of attack is the term of art to talk of such type of precaution, not only in AP1, but also the second 99 protocol to the Hague Convention, last year UN Security Council resolution on the object indispensable, and many others. More importantly, maybe, these precautions must be taken before the belligerent is subject to enemy attack. This is actually one of the few IHL obligations that already applies in peacetime with regard to the location of fixed military installations. Still with regard to 2.3, we would suggest retaining the wording to direct operations only against the military objective. The notion of military objective is not limited to object. Of course, 52 speaks of object, but the wording specify with regard to objects, military objective are, etc. Military objective, broadly speaking, refers to both object and person. So the notion of to direct operations only against military objective is more encompassing and precise than changing it as suggested this morning. 2.3, still, we are very concerned by the proposed amendments on the last sentence. Providing civilians with general protection against the danger arising from military operations is a standalone obligation under treaty law, and is the very purpose, actually, of the rules on the conduct of hostility, and I believe also of this declaration. So the suggested reformulation would essentially turn this sentence into a renvoi to the other obligations that are already mentioned in the previous sentences of this paragraph, depriving this sentence of much, if not all, of its value. We therefore recommend retaining the current language. As for the last part of the sentence about allowing and facilitating rapid and unimpeding passage for humanitarian relief for civilians in need, that's a legal obligation, a treaty, and in our view also under customary international humanitarian law. At a time when the suffering of civilians in ongoing armed conflict, be it in Ukraine, Yemen, or elsewhere, shows the critical importance of access to impartial humanitarian assistance, we strongly caution against undermining this crucial legal obligation and again recommend retaining the current language. Lastly, on 2.3, as promised, we have also a proposal. When discussing section 1 yesterday, many delegations noted that the concern with regards to explosive weapons and their use is not about stigmatizing the weapon, but about the manner in which the weapons are used. That's true, but it's actually about a combination of what, where, and how. What is explosive weapon, where in populated area, and how in compliance with IHL and with any political commitment. So to reflect this point as best as possible while addressing the concerns expressed by this delegation, we would suggest to complete paragraph 2.3 with a more specific reference to the obligation to take all feasible precautions in the choice of means and method of warfare. Indeed, means of warfare refers to the weapons and the method refers to the circumstances and manner, precisely, of using the weapons or the means. So this could come in the middle of the paragraph after the reference to precautions in attacking against the effect of attack, continuing that sentence like this, in particular, the obligation to take all feasible precautions in the choice of weapons, means, and method of warfare. Lastly, the ICRC is not in a position to support the proposed paragraph, the new proposed paragraph in the form that it was proposed with regards to explosive weapons being a legitimate means of warfare. While we have no objections to stating that explosive weapons as a general category are not prohibited under IHL, the way it was proposed, this should be done in a manner that does not imply that all and any explosive weapons are lawful, as this would disregard the prohibition under IHL. And on again. Is it better?
Да. Итак. Sorry, is there a problem with interpretation? Итак, хорошо.
Weapons should not are not.
Не должна предполагать, что не все виды оружия запрещены.
The way it's done should not.
Sorry, apologies. There would appear to be a problem. I'm not aware of what the problem is. Can you not hear on this side? Is that it?
Как представляется, есть проблема небольшая техническая.
It's the interpretation problem, is it?
Okay, the channels are getting mixed up.
Il y a un souci de la ligne anglaise. Ils ont dû switcher un truc et maintenant c'est du russe qu'on entend. Donc les mecs, il faut qu'ils se mettent sur floor pour t'entendre en anglais. Sinon ils t'entendent pas.
D'accord, mais du coup ça, il faudrait que.
Back in Russian. So who do we talk to? Is there anyone from the Secretariat?
Итак,
That's true. Okay, thank you very much. Thank you very much, and thank you to the Secretariat. I think the problem has been resolved, and I'll just ask the ICRC to pick up, just go back a little, I suppose, and pick up where you were, and hopefully we'll be okay. So you have the floor.
Thank you very much, Mr. Chair. And so apologies to those delegations who will hear me for a second or third time for the way I go back a little bit. I will just start reaction to the proposed new additional paragraph. And I was saying that we are not in a position to support the new proposal in the form it was proposed. We have no objection to stating that explosive weapons as a general category are not prohibited under IHL. However, this should be done in a manner that does not imply that all and any explosive weapons are lawful, because this would disregard the prohibition under IHL of anti-personnel mines and cluster munitions, for instance. It should not imply either that military necessity is the criterion that govern their lawfulness. There are many other rules of IHL that do govern their the lawfulness of their use. So we, of course, stand ready to explore alternative formulation that would be agreeable to as many delegations as possible, provided that they address the problem posed by EWIPA in a correct manner and do not undermine IHL. One such option could be as follows. I quote, while there is no general prohibition against the use of explosive weapons under international humanitarian law, every use of these weapons must comply with international humanitarian law. We condemn any unlawful use of these weapons by any actor in any conflict, end quote. And that is the proposal, so in response to the amendment, the new paragraph proposed by a delegation yesterday and supported this morning by others. Thank you very much for your attention and for your patience throughout the statement and the technical glitch. Thank you.
No, thank you very much for your patience. Thank you. I'm going to give the floor now to Austria, to be followed by Belgium. Austria, you have the floor.
Morning to you and to colleagues. At the outset, let me congratulate you on yesterday's meeting. I think we had a very good start to our discussion, and I'm sure we will continue in the same vein. On Section 2, overall, we are very pleased with the current drafting of Section 2 of the political declaration. Before we go into some of the specifics, let me react to some of the proposals made yesterday, which was just also picked up by the ICRC, on the notion of explosive weapons being legitimate weapons. And this is, of course, a very important discussion, and we would like to add some thoughts. A weapon that is inherently disproportionate or indiscriminate is prohibited by international law. And over the years, specific laws, e.g. on weapons of mass destruction, have been adopted to explicitly rule out such inhumane weapons. And of course, also we have the prohibitions of anti-personnel landmines and cluster munitions. The discussions here have made it abundantly clear that this process is a political level commitment to strengthen the protection of civilians from humanitarian harm caused by explosive weapons in populated areas. That is the how these weapons are used. Therefore, the entire draft currently rightly speaks about how weapons are used, which is naturally a focus throughout the entire document. If a weapon is not illegal per se, the question is how it can be used in compliance with international humanitarian law. And here the important point is to adequately taking into account IHL in the legal assessment of a planned attack. Will the expected effects of a weapon's use be in line with the principles of IHL, such as proportionality and distinction? And will the impact assessment accurately take into account indirect effects, which are exacerbated in populated areas, and so on? These are the key questions for this declaration and its implementation mechanism. And we are not aware of any international document that highlights the legality of a particular weapon. So it's completely logical, such as a notion could be misinterpreted as a declaration actually designed to legitimize weapons, rather than to enhance the protection of civilians from the use of such weapons. So in that vein, we want to endorse the comments made by the ICRC just before us. We have a small editorial comment on 2.1, which we will send to you in writing. On 2.2, we are of the view that the declaration should be readable and accessible and should avoid tautologies. So in that sense, the word existing in international law provides the legal framework. So adding existing is superfluous, because how could non-existing IHL provide a framework? So in our view, that word, the word existing is not necessary, because of course IHL as such is the law that exists. On 2.3, in the same vein as a comment made by our German colleague yesterday and supported by others, the expression combatants is a term exclusively used and defined for international armed conflict, but not in non-international armed conflicts. Furthermore, even in international armed conflicts, civilians might directly participate in hostilities and become legitimate targets, in particular with respect to Article 51.3 of the Additional Protocol 1. So we would like to add after the word combatants, the words or other persons directly participating in, which is in the same vein as what our German colleagues proposed, a slightly different wording. And on paragraph 2.4, we have a textual comment which we sent to you in writing, and I just wanted to say that we are open to discuss some of the proposals to further strengthen this paragraph that was made by colleagues yesterday. Thank you very much, Mr. Chair.
Thank you very much. Next speaker on the list is Belgium, to be followed by the Friends World Committee for Consultation. Belgium, you have the floor.
Thank you very much, Mr. Chairman. I will briefly take the floor concerning section 2.3 of the declaration. On 2.3, Belgium welcomes some of the changes inserted in this para that are aligned with previous Belgian comments, including wording regarding the passage of humanitarian relief. My delegation would, however, prefer using the word access rather than passage. I thank you.
Thank you. And I give the floor next to the Friends World Committee for Consultation, to be followed by the Philippines. Friends World Committee, you have the floor.
We would like to align ourselves with the addition suggested by Wilf on a new paragraph that recognises that states continue to have obligations to respect, protect and fulfil human rights in armed conflict, and must exercise human rights due diligence related to the use of weapons, and further must assess the human rights impacts of such. Secondly, on 2.5, we suggest an addition of international human rights law after international humanitarian law, and in complementarity to the references to the Security Council resolutions, we suggest references to Human Rights Council resolutions such as 2435, 3212, 4120, 2910 and 3810 on arms transfers and acquisitions that concern the impact of arms transfers and acquisitions of arms on human rights, which are directly linked to the use of explosive weapons and their impacts. Thank you.
Thank you very much. Next speaker is Philippines, to be followed by Mexico and Chile. Philippines, you have the floor.
Mr. Chair, at the onset, the Philippines wishes to thank Ireland for the arrangements for this week's meeting, for the preparation of the draft political declaration text, and for its overall leadership of this process. The Philippines has been fully engaged in the process towards a political declaration to address humanitarian harm arising from the use of EWIPA. This is rooted in our strong commitment to IHL and is guided by our twin advocacies of victim centrality and independent national capacities in humanitarian disarmament work. We are delighted to see strong elements emphasizing harm to civilians, including explicit recognition of lifelong disabilities arising from injuries from EWIPA, the references to the reverberating effects, including those arising from damage and destruction to infrastructure, and the recognition that meeting the people's basic needs is a challenge in crisis situations where EWIPA is used. We also welcome references to rapid and unimpeded passage of humanitarian relief for civilians in need. While the language on victim assistance is already robust, we believe that we could still do more, not only to meet their basic needs, but to also to facilitate their full socio-economic reintegration, the full realization of their rights, and their full participation as members of communities and societies. We could also do more to ensure full and unimpeded access for humanitarian relief in line with international norms and standards. The Philippines is guided by its own national experience, where violations of IHL arising from EWIPA use are often perpetrated by armed non-state actors that often use civilian and civilian objects as shields. This must be clearly condemned. Mr. Chair, since we were unable to take the floor yesterday, we wish to begin by registering our comments under Section 1. Under this section, the Philippines welcomes the characterization of the humanitarian impact and the reverberating effect of the use of EWIPA, including indirect effects stemming from damage to or destruction of critical civilian infrastructure. We also welcome the impact of these risks and reverberating effects to the achievement of the Sustainable Development Goals. There is a direct link between the safety and security of communities and their livelihood and sustainable development. We support references to the imperative of addressing the short and long-term humanitarian consequences resulting from armed conflict involving the use of explosive weapons in populated areas. We note, however, that these consequences could also arise outside of armed conflict. We support condemnation of exploitation of civilian and civilian objects to military objectives in populated areas and the use of IEDs. These are usually undertaken by armed non-state actors, ANSES, more than states. Regarding Section 2, the Philippines welcomes references to the application of international human rights law and the affirmation of obligations to hold accountable those responsible for violations of both IHL and IHRL, and our common commitment to end impunity. We agree that IHL provides the legal framework to regulate the conduct of armed conflict and is applicable to EWIPA use. While IHL applies to both states and armed non-state actors in times of armed conflict, our national experience demonstrates that armed non-state actors have a higher propensity to violate IHL due to either demonstrable lack of understanding or incentives to comply. Accountability mechanisms that exist in states are also often absent in non-state actors. We therefore welcome the condemnation of tactics that exploit the proximity of civilian and civilian objects to military objectives to populated areas. However, it must be clearly stated that this is often employed by armed non-state actors way more than states. Finally, we also believe that a preambular language on the need to take into account gender-based differentiation of the consequences of EWIPA use, in addition to the references in the operative sections, is appropriate. Thank you, Mr. Chair.
Thank you very much. Next speaker on the list is Mexico and Chile, to be followed by Article 36. So Mexico, you have the floor.
Thank you so much, Chair, and we're sorry to arrive late. Unfortunately, we don't have the power of ubiquity, and there are several meetings going on at the same time. We welcome the changes made to this Section 2 which tries to encapsulate all provisions regarding legal obligations, which were previously haphazardly scattered in the draft in a comprehensive manner. The text is also much improved on how it reflects the current obligations and commitments under international law, particularly IHL and international human rights law. We only have two specific comments to this section. With regard to 2.5, besides welcoming the work of the UN Security Council to strengthen the protection of civilians, we also believe there should be a recognition of the work done by the General Assembly on this issue, as well as to the reports of the Secretary General that have played an important role raising awareness and documenting the general situation of protection of civilians in a comprehensive manner. Therefore, we would suggest the following language that we will convey, of course. We welcome the work of the United Nations Security Council and the General Assembly to strengthen the protection of civilians during armed conflict and to strengthen compliance with international humanitarian law, recalling in particular the UN Security Council resolutions on the protection of civilians in armed conflict and the high-level segment of the General Assembly on protection of civilians, and call upon those organs to further advance their work on this issue to effectively protect civilians. We also welcome the reports of the UN Secretary General on this issue that have played an important awareness-raising role and documenting the general dire situation of civilians in armed conflict in a comprehensive manner. We also consider that a new paragraph can be added that recalls the specific protections under IHL provided to specific civilian objects, such as medical units and transports, which refers, among others, hospitals and other similar units, blood transfusion centers, preventive medicine centers and institutes, medical depots, and medical and pharmaceutical stores, medical transport, including means of transportation by land, water, or air, cultural property that refers to property of religious, art, education, charitable purposes, and historic monuments, the natural environment, and the works and installations containing dangerous forces, including dams, dikes, and nuclear electricity generating installations. We will provide a paragraph on this regard. With regard to the comments that we have listened yesterday and today, we would like to make the following observations. With regard to the proposal by France and Germany to add the language of the UNGA resolution that there is a reference to the condemnation of the indiscriminate attacks against civilians and civilian objects, including indiscriminate shellings, our delegations can accept this proposal encapsulated in this section on the understanding that it does not cover the totality of the areas of concern of this declaration, as we have explained previously in our position in section 1. On the additional value of the political declaration is the additional value of the political declaration are the policy considerations with a view to providing effective protection of civilians from harm. We also welcome the very pertinent proposal by Wilf to include an additional paragraph that clarifies the application of international human rights law during armed conflict and the obligation of due regard in that context. On other technical aspects, we would like to support the explanations just given by the ICRC on its latest statement. In particular, we appreciate the clarification that although there is no provision under IHL of all explosive weapons due to their inherent characteristics, inherently inhuman or of excessively injurious, there are some that have been identified to be so, and the rules of IHL still apply that might make them illegal due to their use. This should be the understanding on the drafting of any paragraph in this regard, which is in agreement with what has just been also explained by Austria. Thank you so much.
Thank you. I now give the floor to Article 36, which is the last speaker on my list for the moment. So if anybody else does wish to take the floor, please raise your flag. Article 36, you have the floor, please.
Thank you, Chair. Article 36 would like to briefly respond to a couple of points that have been raised by some delegations, particularly yesterday. First, in response to the position of some delegations that the declaration's scope should be limited solely to the indiscriminate or unlawful use of explosive weapons, we believe such an approach would undermine the humanitarian value of the future declaration by reducing it to a simple political reaffirmation of states' obligation to follow the law. It is still further flawed in important respects. First, states calling for this limitation have not explained how they have determined that civilian harm only results from indiscriminate or unlawful attacks. There's been an ongoing pattern of harm to civilians documented as resulting from the use of explosive weapons in populated areas. Such data gathering faces numerous challenges, yet the broad pattern of harm has remained consistent in different contexts and over many years. A significant number of the incidents that have produced civilian harm would likely be considered illegal if subject to legal prosecution. However, it's not possible, based solely on data regarding weapons used and resulting casualties, to determine if an attack was illegal under international law. Such a legal determination also requires knowledge of a host of other considerations. For many incidents of explosive weapons use, those states calling for a limitation of the declaration's focus do not have access to the necessary information and have no capacity to formally determine whether the attacks were indiscriminate or not. Second, focusing only on indiscriminate use risks politicizing the experience of civilian harm by selectively asserting which attacks are illegal, based not on detailed evidence or formal legal judgments, but rather on the basis of the identities of the parties in question. As a result, civilian harm arising from the actions of one's own or allied forces may be treated skeptically or dismissed, or incidents explained away, whilst the label of illegality is quickly applied to the actions of parties that one is opposed to. Such a politicizing approach is not a good basis for developing a declaration intended to strengthen civilian protection generally. Third, a focus on indiscriminate use implies that civilian harm from attacks that are not illegal is not worth consideration. Yet people are killed and injured and experience long-term suffering from so-called incidental harm. The fact that the attack that caused the harm is not judged to be illegal does not erase the reality of that experience or lessen its practical impact on the lives of those affected. It runs directly counter to the object of this process to strengthen the protection of civilians, to remove from consideration how civilian harm might be avoided or minimized in attacks that are considered lawful. Finally, states calling for this limitation have also not explained what humanitarian benefits could be expected from this approach and how it would strengthen the protection of civilians. Proponents of this approach should be wary that they are promoting a position that cannot be supported by evidence, that is corrosive of established international law, and that exposes them to awkward political questions. Like others, we support the broad framing as currently reflected in the draft declaration, which allows for a declaration that functions as an important practical tool for the promotion of stronger civilian protection and strengthens operational practice in support of the existing legal framework. The other point we wish to respond to is the concern of some delegations that the political declaration should not refer to or address so-called novel concepts because they are not recognized as formal legal terms. The aim of the political declaration is to strengthen the protection of civilians and to reduce civilian harm from the use of explosive weapons in populated areas. In order to do so, the declaration must accurately describe the scope and nature of the harm to be addressed and the specific characteristics of explosive weapons that give rise to such harm. Existing legal terminology does not provide us with the tools for this task. First, indirect effects does not properly capture the cumulative and knock-on effects that result from the use of explosive weapons in populated areas, as compared to reverberating effects, a term that we and others, including a number of states, the UN Secretary General, and the ICRC have used for several years, and which has been the subject of considerable analysis and discussion. Similarly, wide area effects, again a term that has been widely used for several years, describes physical characteristics of certain explosive weapons in certain contexts that have a direct bearing on the likelihood and likely severity of civilian harm. Militaries recognize in policy and practice that certain weapons, due to the scale of their area effects, will present an elevated likelihood of civilian harm if used in a populated area. We can recognize this in a political declaration and work together to strengthen consideration of those factors in practice. Failure to properly describe the problem and its causes will inevitably result in incomplete responses. Moreover, the political declaration is seeking to respond to the broad range of harms resulting from the use of explosive weapons in populated areas. Its strength lies in the fact that as a political declaration, it can be dynamic and progressive, both in terms of how it presents and describes those harms, and in terms of the responses that it proposes to address them, through the articulation of policy commitments to be implemented at the national level and not the creation of new legal obligations. Again, we see certain states calling for a political declaration, but one that only uses legal terms and does not say anything different from existing law. This is not a basis for strengthening civilian protection. It is a basis for saying absolutely nothing. If we are a community that is genuinely committed to protecting civilians, then we really need to do better than this. Thank you.
Thank you. I now have further speakers for this section. I'll hand the floor to Norway, please. Norway, you have the floor.
Thank you. Norway can support Chapter 2 as it stands now, which is a significant improvement over previous versions. And we also believe that moving paragraph 2.4 from Chapter 1 to Chapter 2 was sensible. We've noted the US's argument that different states might have different obligations and that we should avoid reflecting legal obligations in Chapter 2 that do not apply to all, in order to avoid creating a hurdle for those states to then endorse the declaration. As we see it, the legal requirements reflected in Chapter 2 as it currently stands are generally applicable to all states. That being said, as we mentioned yesterday, we generally find that mere restatements of well-known legal obligations has limited added value. So a solution could be to shorten Chapter 2 significantly and only reaffirm or recall the legal obligations that we have under IHL in more general terms. But as I said, we think the current draft is good and can be kept as it is. Regarding the French-German proposal to expand the list of issues under paragraph 2.4, we have no problem with condemning violations of IHL. We nevertheless question the value of including many such condemnations of IHL violations in abstract terms. And that goes again back to the issue of focus. It would add to a text that is already very long. It states the obvious, and it takes the focus away from the core of what this political declaration is about, namely how we can work to improve the protection of civilians in the particular case of a WIPA. And condemning obvious IHL violations in the abstract does not contribute so much to that. And that brings me to our last point at this stage. Yesterday, we heard calls to include the word indiscriminate before all instances of a WIPA in the text, which is something that we firmly oppose. It would give the factually incorrect impression that only indiscriminate use of a WIPA causes civilian harm. Also, as Chile and Mexico and others have pointed out, indiscriminate attacks are illegal per se. We don't need to underscore that. If we start going down that route, we would have to add or disproportionate or lacking precautions and the point is that a WIPA with wider effects is a cause of great humanitarian harm, and we should do our utmost to protect civilians from this. Qualifying a WIPA with cuts and pastes from IHL is neither necessary nor helpful, in our opinion. Thank you.
Thank you, Norway. I now hand the floor to the United States, which for the moment is the last speaker on my list for this section. United States, please.
Thank you very much, Mr. Chair. Just a couple of quick points in response to some of the things that have been said. I know that we're not negotiating text here, which makes it a little awkward because we've started to actually get into some textual back and forth. And I don't want to leave the impression that if we do not respond to if we made a proposal or someone else made a proposal on text and someone responded to it, the failure to respond means that one has no reaction to that response. I don't want to leave that impression. But at the same time, I just wanted to make a couple of quick responses. Ultimately, on some of these points, it may be necessary, if not at this session, maybe at the next session, for delegations to sit down and try to find a creative compromise between different positions. The first point on section 2.3, our colleagues from the ICRC referred to the last provision, the last point in that paragraph, which refers to the passage of humanitarian relief, which of course is a critical aspect of addressing the humanitarian calamity of armed conflict. But here in particular, there are different obligations depending on if a state is a party to the Geneva Conventions alone, or whether it's also a party to Additional Protocol 1. The proposal the United States made was one that was broad enough to cover states which are not parties to AP1, and AP1 has a more specific obligation. And it also reflects language that's been used widely in United Nations resolutions on this point. The second issue I wanted to come back to was the U.S. proposal for an additional 2.4 bis. And here again, I think it's a perfect illustration of the need in this declaration for balance. We heard quite a bit of debate yesterday about whether the humanitarian statements in this declaration, such as in 1.2 and 1.3, where the word can is introduced. The use of explosive weapons can have a devastating impact. We heard delegations say that's terrible. We can't say can. We have to be clear about what the humanitarian concerns are. Well, remember that this declaration is aimed at states with militaries that are carrying out armed conflict. And from the standpoint of our governments, we start with the proposition that we have explosive weapons in our arsenals, and when we conduct armed conflict, we use them. And that's what the U.S. proposal for 2.4 was meant to reflect. And so we immediately saw a reaction that said, no, we need to make sure we have the caveats in there, the restrictions under IHL, the cans in effect. So my point is that while we probably can find some language that would work between the ICRC proposal and our proposal in that area, we have to keep in mind that we're seeking balance here in all aspects of the declaration. And so we have to take that same approach for every provision. Next, we heard Mexico and Chile wanting to elaborate very much on a series of resolutions in the UN General Assembly, UN Security Council. I think we would want to echo the wise remarks made by Norway that we probably should show some drafting restraint in the declaration and try to keep it as focused and short as is possible. And finally, again, on the balance issue, we heard some very sincere comments this morning, which echoed things that we heard yesterday, that existing law says nothing. And I'd really like to take issue with that point. Existing law is what this is all about. It's IHL that sets up humanity as a critical issue that must be taken into account when we're looking at military necessity. And we shouldn't act as if citing IHL or making sure that what we're saying is not inconsistent with IHL or doesn't suggest that we're creating new rules or new interpretations of IHL, that somehow that's a defeat, because it's not. IHL is what we have to rely on here in order to really give protection to civilians. Thank you very much, Mr. Chairman.
Thank you. I hand the floor now to Australia, please. Australia, you have the floor.
Thank you very much, Chair, and good morning, colleagues. This is the first time that my delegation has taken the floor in this meeting, so I would like to begin by thanking you, in particular for the inclusive and transparent manner in which you are conducting these consultations. So thank you indeed, and you can count on our delegation's constructive engagement. On section 2, my delegation just has a few comments to make. On paragraph 2.1, we feel there is some lack of clarity in some respects. The reference to commitments alongside obligations under international humanitarian and human rights law is a bit unclear. International law imposes legally binding obligations as opposed to non-legally binding commitments. And so we would support amending this paragraph to reflect this distinction. We also have a technical point regarding the reference to an obligation to hold accountable those responsible for violations. We think this terminology does not accurately reflect the requirements contained in IHL or international human rights law, and results in the paragraph being overly broad. So rather than frame this as a discrete general obligation, we would propose rewording this to read, including responsibilities to hold accountable those responsible for violations, which would avoid the difficulties of trying to capture the precise wording of obligations, which may, for example, differ depending on the classification of the armed conflict. We consider that the term responsibilities better reflects that, even in the absence of a legal obligation, states have a responsibility to hold those responsible accountable and to end impunity. Moving now to paragraph 2.3, we would welcome the inclusion of impartial in the facilitation of passage of humanitarian relief. So this would read, and facilitate rapid and unimpeded passage of impartial humanitarian relief, which would more closely align with IHL. And finally, on paragraph 2.4, we would encourage the declaration to more explicitly condemn the indiscriminate use of IWIPA by all belligerents, and in particular the use of improvised explosive devices against civilians or civilian objects. So to that end, we would suggest the declaration would benefit from splitting both elements of paragraph 2.4 so that it would read, we condemn tactics designed to exploit the proximity of civilians or civilian objects to military objects in populated areas. We further condemn the use of explosive weapons, particularly the use of improvised explosive devices directed against civilians or civilian objects and other violations of IHL, including by non-state armed groups, which further exacerbates the risk to civilians and are of grave concern. So, Chair, those are our comments on section 2. Again, thank you very much.
Well, thank you, Australia. I now hand the floor to New Zealand. Please, New Zealand, you have the floor.
Thank you, Mr. Chair. Having listened carefully to several interventions yesterday afternoon and also this morning, New Zealand would like to make a couple of points. Section 2 of our political declaration is of vital importance. We must make sure that it is drafted with great care so that we avoid it raising any questions or causing any confusion around the requirements of IHL. In this regard, we are appreciative of the comments put forward by the ICRC, including their very helpful and clear intervention this morning. The current draft, in our view, balances these twin pressures well. As others have mentioned, the purpose of our political declaration is not to create new or reiterate all existing international humanitarian law. Instead, our mission is to add an additional layer of political commitments that will improve the status quo for civilians in conflict zones and properly extend to them the full protections of IHL. As conflict has become increasingly urbanized, the application of existing IHL, whether through a lack of common understanding or implementation, has resulted in significant civilian harm and tragic humanitarian consequences. Our delegations are gathered here today precisely because we all acknowledge that. But the value of our declaration will be significantly constrained if it is limited only to reiterating our commitment to the status quo and only restating a conservative reading of our international legal obligations. I thank you.
Thank you, New Zealand. I don't see any other speakers on this section. So if that's the case, I just want to thank everybody for that very fruitful discussion that we had on section 2, and in particular to thank those delegations as well that engaged in a very interactive exchange and responsive exchange. That's exactly the type of discussion that's very helpful to us as chair. As Ambassador Gaffey mentioned yesterday and this morning, we'll move now to section 4 of the text. Section 4 of the text, of course, is the final section. We'll move to section 3, hopefully in the afternoon. But this section sets out a number of operational commitments, which are intended to underpin the political message of the text and practical actions to drive effective change. Paragraph 4.1 commits states to strengthen international cooperation and assistance among armed forces and other relevant stakeholders with respect to tactical and technical expertise. The revised version also adds humanitarian impact assessments in this paragraph. The strengthening of international cooperation is intended to help develop and improve good practices in relation to the protection of civilians. Paragraphs 4.2 and 4.3 operationalize the commitment made in paragraph 1.6 relating to data collection and calls for the collection and, where feasible and appropriate, the sharing of disaggregated data on the effects on civilians of military operations involving the use of a WIPA. It also calls on states to facilitate the work of the UN, the ICRC, and relevant civil society organizations in their data collection efforts. Paragraph 4.4 contains an extremely important provision in the text on victim assistance and includes a commitment to provide, facilitate, and support assistance to people critically injured, survivors, families, and communities affected by armed conflict. The text calls for this to be done in a holistic, gender-sensitive, and non-discriminatory manner, and it also establishes the right of persons with disabilities to be taken into account. Paragraph 4.5 includes a reference to states facilitating the work of the UN, ICRC, and civil society organizations in relation to the protection of civilians as appropriate. We've consistently said that the conclusion of a political declaration on a WIPA is the beginning rather than the end of the process. And paragraph 4.6 calls for those states that signed the declaration to meet on a regular basis to review its implementation and identify any relevant additional measures that may need to be taken. Additionally, it also sets out a very concrete proposal for a group of interested states to meet as a starting point to develop a compilation of good practices on the protection of civilians, which then could form the basis for a structured military-to-military exchange, including workshops and seminars. The revised version of the text also calls for the participation of the UN, ICRC, and civil society in that activity. And finally, then, paragraph 4.7 relates to the promotion of the declaration and its distribution to all relevant stakeholders, and also calls for states to seek its adoption and its effective implementation by the greatest possible number of states. So with that, I'll open up the floor for a list of speakers on section 4. I think we already have a few delegations that have raised their flag. And so I'll start with Israel. Israel, you have the floor, please, to be followed by Turkey.
Thank you, Mr. Chair. I'd like to share our comments for section 4. Regarding paragraph 4.1, Israel attaches great importance to cooperation between armed forces and believes that such cooperation would be very beneficial and assist in promoting the protection of civilians. This paragraph focuses on cooperation between armed forces as well as other relevant stakeholders. However, it is unclear to us who these is referring to. In our view, the goal of this article should be promoting the cooperation and assistance among armed forces, and therefore we suggest deleting the words other relevant stakeholders. Regarding 4.2, as we stated in 1.6, in a declaration with the purpose of improving the protection of civilians, it is vital to include a reference to the conduct of non-state armed groups who often deliberately conduct their operations from within populated areas while making use of human shields, as well as other tactics designed to exploit the proximity of civilians and civilian objects to military objectives. Therefore, in this article, we suggest adding a reference to the importance of collecting data on these aspects, as they are a crucial element of urban warfare and can help inform policies and efforts by states to further the protection of civilians. Furthermore, as previously stated, we would suggest deleting the phrase reverberating effects from this paragraph. Regarding 4.4, this paragraph establishes a strict and wide obligation on the state, not only towards its citizens, but also towards people of other belligerents. This is unrealistic, both financially as well as politically. Moreover, different states have different obligations under international law regarding assistance to people affected by the armed conflict. And this issue is also subject to specific national law and policy. Therefore, we suggest adding the word appropriate before the word assistance and the words in accordance with applicable international law as well as with relevant national law and policy in the end of the paragraph. Regarding paragraph 4.6, as a matter of principle, Israel supports professional exchanges between states on IHL implementation and is constantly engaging in such exchanges in different forums. However, Section 4.6 is much broader in scope and extremely problematic for a number of reasons. First, the suggested forum sits way beyond the scope of the current declaration and could have far-reaching implications on both the legal and political levels. Secondly, without making essential determinations regarding the nature and format of this forum and setting a number of appropriate safeguards against politicization, this forum could easily become a politicized forum, which would be counterproductive in relation to its original goals. In order to have a serious discussion on establishing such a forum, a number of vital questions must be addressed. What entity or state would chair the discussions and set the agenda? Who would fund it? Who would participate in such a body? What would the forum's objective and mandate be? What would the rules of procedure of this mechanism be? Would this body take decisions? Would it produce outcomes? And so on. We recall the consultation process initiated by the ICRC in Switzerland in 2012, which lasted a few years on establishing an IHL compliance mechanism. These consultations delved into the smallest details of such a potential mechanism, and there were varying visions between states on how it would look like. In the end, no agreement was reached. We find it questionable and concerning to attempt to establish such a new framework in two general sentences that lacks adequate framing, qualifications, and safeguards. Establishing this kind of framework through this declaration and reaching agreement on the important questions we have just raised as part of the current negotiation is impractical. Therefore, Israel opposes this paragraph and asks for its deletion. Alternatively, we suggest the following modifications. And I quote, and it's going to be long, and I will send it in writing, of course. Explore the possibility that states meet to exchange their own best practices in a professional, non-politicized, and non-contextual manner on a voluntary basis regarding the implementation of international humanitarian law and the strengthening of protection of civilians and civilian objects with regard to armed conflict involving the use of explosive weapons in populated areas. For example, a group of interested states could develop a compilation of good practice, which could form the basis for structured military-to-military and other exchanges, workshops, and seminars. End of quote. Any such framework would, of course, require prior deliberations and consultations. However, we believe this could be a sufficient basis for the purposes of this declaration. And lastly, regarding paragraph 4.7, we noticed that the words effective implementation were added to this paragraph. In order to streamline the text, we would suggest moving the phrase to the end, and it would read, and I quote, actively promote this declaration, distribute it to all relevant stakeholders, and seek its adoption by the greatest possible number of states and its effective implementation. We believe this is also a more practical and realistic approach. I thank you, Chair.
Thank you, Israel. And yes, indeed, please do submit your proposals in writing. That would be very helpful. Next on my list is Turkey, to be followed by France.
Thank you, Mr. Chair. In 4.1, other relevant stakeholders contains ambiguity. Stakeholders should be specified in order to clarify their relevance, or that part should be deleted. Unfortunately, there is enormous information pollution in today's world, and even facts can be reflected differently by using discourse. Some people use discourse artfully and apply it by using technical methods. Public opinion is impacted dramatically by the use of discourse. So, in our opinion, only UN and UN agencies should be supported to capture data on military operations impact. We have seen that in order to increase awareness of the impacts of the use of EVPA, some NGOs are gathering all the information that they could get without verification, even from the terrorist organizations, which are using the good intentions of that NGOs. And such baseless information creates greater separations between people and fuels conflicts. Accordingly, we propose 4.3 as follows. Facilitate the work of the United Nations and UN agencies, collecting data on the impact on civilians of military operations, involving the indiscriminate use of explosive weapons in populated areas as appropriate. In 4.5, we propose that instead of other relevant international organizations and civil society organizations and humanitarian organizations should be used. Again, it would be better to include the qualifier indiscriminate before the use of EVPA in 4.1 and 4.5. In 4.2, instead of the reverberating effects term, indirect effects should be used. Mr. Chair, in 4.6, we could support exchange of good practices and lessons learned between military to military, but there is no need to create any new fora. We should concentrate on developing our national legislation to implement this declaration. 4.6 should be read as identify any relevant additional measures by reviewing national legislation for the implementation of the commitments in this declaration and improving compliance with obligations of states under IHL. In the last operative paragraph, 4.7, for this is political declaration, we would like to see participation to it instead of its adoption. Thank you, Mr. Chair.
Thank you, Turkey. I now have France to be followed by Germany, please. Thank you.
Merci, Monsieur le Président. Bonjour.
Thank you, Chair, and good day to everyone. This is the first time my delegation has taken the floor this morning. On section 4 of our document, well, I'd like to thank Ireland for this proposal, as indeed for sections 1 and 2. We think that this amended version is moving in the right direction and is almost ready for adoption. I wanted again to thank you because you've done very impressive work. Thank you very much. I just wanted to make a few comments on a few paragraphs with a view to improving their readability. On 4.2, which deals with the collection and sharing of data, I would just like to recall that my country is totally in favor of strengthening the collection and sharing of data. However, we do believe that there are operational and security constraints that have to be borne in mind, really. And this is why we would like to move the phrase where feasible and appropriate to after disaggregated data, because the collection and sharing of data are subject to these operational and security constraints. And I don't think that we can turn a blind eye to that. On 4.3, we support the vital role played by the ICRC, the United Nations, and civil society as a whole when it comes to collecting data. That goes without saying. So this paragraph must be kept in the text. It is very important. We would just propose that we replace military operations by armed conflict so as to have a more appropriate legal term used in the text. On 4.4, you have said this, Chair, this is an essential paragraph on assistance to victims for our future declaration. We think that this paragraph must more clearly reflect the obligations incumbent on states in this respect under existing IHL. When we are obligated to assist the victims of such attacks, we have to do so in an integrated fashion, holistic, and a way which takes into account the specific needs of those hardest hit or most affected. We will send you some language which will reflect what I've just said in more specific terms. And on 4.6, lastly, which is an extremely important paragraph because it talks about the follow-up and the subsequent steps to be taken with respect to our political declaration. It is essential, and I have already had a chance to talk about this during earlier meetings, but this political declaration is not an end in and of itself, but should spark off the beginning of a process of consultations aimed at allowing states to exchange views on specific practices and measures which could be implemented so as to strengthen in tangible terms the protection of civilians. And this means establishing an effective and operational working channel of communication among military personnel and to exchange the sharing of data. And to clarify this idea, we are also going to be sending in to you a proposed amendment along these lines. So I will confine myself to those comments, and thank you again, Chair, for this excellent proposal.
Merci, La France.
Thank you, France.
Me on my list to be followed by air wars.
Thank you very much. Mr. Chairman, as Ambassador Gaffey stated in his opening statement yesterday, the political declaration that we are working on this week does not represent an end point, but the start of a process aiming at ensuring a better protection of civilians. This corresponds to the approach that we have taken since the inception of the debate around EWIPA, and we are satisfied that a meaningful follow-up process is now firmly anchored in your draft, inter alia on the compilation of good practices in order to improve compliance with international humanitarian law. We do realize that different ideas and notions exist on different state or international levels on how to grasp and measure indirect effects or reverberating effects concretely, as well as how to take foreseeable indirect or reverberating effects into account when conducting a military operation, such as the NATO Handbook on the Protection of Civilians, as well as considerable research, among others, by UNIDIR and the ICRC. With regard to the protection of civilians in general, we believe that we would benefit from a systematic comparison and exchange on this subject in the context of the follow-up process to this declaration. Therefore, we propose to use the follow-up process not only for an exchange on good practices in the application of IHL, but also for an exchange on how to best grasp and measure foreseeable indirect effects or reverberating effects, as well as on military good practices on how to effectively take these effects into account when conducting a military operation. We suggest to clarify the different concepts of indirect or of reverberating effects that are the subject of a lot of controversial comments in our discussions, in the discussions referred to in paragraph 4.6, rather than simply deleting reverberating effects, as suggested by some throughout the text. We therefore propose to use indirect effects in the declaration, as this term seems to be less contested. We therefore would support, would suggest the inclusion of an addition to this effect in the middle of paragraph 4.6, which would read, meet on a regular basis, and then after with regard to armed conflict involving the use of explosive weapons in populated areas, add including how to better understand the notion of foreseeable indirect effects and to conceptualize and operationalize relevant IHL principles in regard to this notion. And then the paragraph should follow on like you proposed. These amendments are to be read in conjunction with the commitments set out in section 3, more specifically paragraphs 3.3 and 3.4, that we will be addressing later. In the same vein, then paragraph 4.2 should be amended to read, collect and where feasible and appropriate, share and make publicly available disaggregated data on the direct and indirect effects on civilians of military operations involving the use of explosive weapons in populated areas. So exchange reverberating against indirect. Mr. Chairman, in previous statements, we have advocated to use this declaration also as a strong signal to those actors that cannot or do not wish to sign this declaration. To strengthen the message, we propose the following changes in the spirit of the changes already suggested for previous sections. In line with our suggestion regarding taking into account in the declaration the actions of non-state actors, the data collection on the impact on civilians referred to should not be limited to military operations, but also the actions of non-state actors. Therefore, we suggest to insert into 4.3 a phrase to that effect that would now read, facilitate the work of the United Nations, the ICRC, and relevant civil society organizations collecting data on the impact on civilians of military operations, as well as damage caused by non-state actors involving the use of explosive weapons in populated areas as appropriate. In a similar vein, the promotion of the commitments in this declaration set out in the final paragraph 4.7 should not be limited to states, but to all potential parties to armed conflict. While non-state actors cannot subscribe to the declaration, they can adhere to it and also respect the commitments. We therefore suggest to add at the end of paragraph 4.7 a sentence, and adherence mutatis mutandis to the commitments in section 3 by all parties to armed conflict, including by non-state armed groups. Finally, regarding victim assistance, we believe that the paragraph 4.4 would benefit from the following addition at the end. First of all, at the beginning, we would like to suggest the addition of victims in the first line that would now read, provide, facilitate, and support assistance to victims, i.e. people critically injured, survivors, families of people killed and or injured, and communities, and so on. And then add at the end of the paragraph, victim assistance includes ensuring basic needs are met and safe and timely access to the provision of emergency medical care, physical rehabilitation, psychological support, and socioeconomic inclusion, as well as support towards the full realization of the rights and full participation of victims in societies. We will hand in all those suggestions in writing. Thank you.
Thank you, Germany. I now have Air Wars on my list to be followed by Norwegian People's Aid.
Thank you. We'd like to thank the chairperson and the Irish delegation for their continuing engagement on this critical issue. We understand the challenges of your task, and we support you and all of the states here today in your efforts to find a constructive solution to the problem of civilian harm in populated areas. Our organization, Air Wars, monitors at scale civilian harm in a variety of conflicts based on all-source social and local media reporting. Our data is regularly used by states, militaries, and civil society as a trusted reference point to help understand where, when, and how civilians are being harmed by explosive weapons use. As a member of INU, we're in complete alignment with the statements made by that network and our colleagues from civil society here today. In order not to take too much time today, we'll focus only on those additional elements of the draft statement we feel best placed to speak to. In particular, we have specific contribution to section 4.2 regarding the caveat where appropriate, currently used in connection to the collection, sharing, and publication of disaggregated data on the direct and reverberating effects of civilians and civilian objects. Affected civilians know when harm takes place. and they're often able to identify who's the perpetrator of that harm. They are reporting on it at scale and in real time. Ukraine is just one example of how civilians are reporting on and documenting the horrors of war, even as they are living under it, under attack. To date, our organization alone has assessed and archived over 100,000 unique local sources across 8 conflicts alleging civilian harm resulting from the use of explosive weapons. The majority of the incidents have occurred in populated areas. Using the caveat where appropriate will, we fear, absolve states of the responsibility for really listening to those communities under attack. It will fall short of an essential commitment among states to recognize and respect those voices and share their findings with the communities they have harmed and the civil society groups working with them. During later discussions on the operative section 3, we'll assert in further detail our position on the imperative of tracking, analyzing, responding to, and learning from civilian harm monitoring and documentation. But critical to that discussion is the connected section 4.2 bis on the commitment to gather data on the use of explosive weapons, including the location of areas targeted. This information is an essential element of the evidence base that will help states, militaries, civil society, humanitarian actors, and affected communities understand civilian harm in conflicts. With information on where and how weapons are used in conjunction with granular data on how such weapons have affected civilians and civilian objects, we will all be able to access a clear and comprehensive evidence base that can inform and shape future decision-making. This, at present, is a critical information gap. Finally, we would like to express support for states such as Uruguay, Ecuador, and Finland, amongst others, who note the importance of collecting disaggregated data at further levels, including the collection of data on the impact of conflicts on those with disabilities. We are one of many civil society organizations that strive to collect and disaggregate such information, and we call on the powerful states represented in this room to do the same. Thank you.
Thank you. I now hand the floor to Norwegian's Populated, to be followed by Spain, please.
Thank you, Chair. I actually speak on behalf of INU, and I will now present INU's general comments to Section 4. This section is a very important one, providing core humanitarian commitments such as victim assistance, and it addresses collection and sharing of data, as well as follow-up. And as INU, we were pleased to see many improvements from last time in this draft that we're discussing today, and particularly positive were the changes made to 4.4 on victim assistance. So please allow me to give some more detail on our suggestions, starting with 4.2 on data collection. Data collection matched with the commitments to be transparent over data sharing and to investigate credible allegations of civilian harm can help to promote better protection of civilians and to promote compliance with international law. Data collection on the consequences of the use of explosive weapons, both the direct and reverberating effects, is crucial for understanding and responding to civilian harm. So our suggested wording for 4.2 would be collect, share, and make publicly available disaggregated data on the direct and reverberating effects on civilians and civilian objects involving the use of explosive weapons in populated areas. Furthermore, INU suggests an additional commitment after 4.2 on collecting and sharing data on the use of explosive weapons, including the types of munitions, locations, and quantities used. Gathering this information is important for building understandings of impacts of explosive weapons use. This includes the risks and effects of explosive ordnance or explosive remnants of war. Such data would help mine action organizations, for example, to do clearance, risk education, and put resources to where they are most needed. So our suggested wording for a 4.2 bis would be collect and record the location and areas targeted using explosive weapons, including the approximate number of explosive weapons used, the type and nature of explosive weapons used, and the general location of known and probable unexploded ordnance. Let me now turn to victim assistance and paragraph 4.4. As mentioned previously, the provisions on victim assistance is now significantly improved. However, it could be further strengthened by laying out what victim assistance includes, and I will present what we want to add to the paragraph 4.4 without reading the whole thing. So we would like to add that victim assistance includes ensuring basic needs are met, and safe and timely access to the provision of emergency medical care, physical rehabilitation, psychosocial support, and socioeconomic inclusion, as well as support towards the full realization of the rights and full participation of victims in societies. We also suggest a short new paragraph under 4.4 on supporting humanitarian relief and access. And we do welcome the reference to rapid and unimpeded passage of humanitarian relief for civilians discussed in the legal section. However, we're concerned that it only mentions passage and not humanitarian access. Passage is usually understood as more constrained and less sustained, whereas humanitarian access would be a broader concept. We therefore would like to suggest the following for an additional short little paragraph, which could read, provide and facilitate safe, rapid, and unimpeded access for principled humanitarian relief in line with international norms and standards for providing principled and inclusive humanitarian assistance. Lastly, let me turn to the very important 4.6 on follow-up. This is indeed a very important commitment for an effective follow-up process. So such a process should be inclusive, and the main purpose of meetings should be to review the implementation. The declaration should not suggest a few types of selected activities, which could be undertaken by certain actors, which would be unnecessarily limiting in our view, but it should rather be broader. So such limits sits awkwardly with the declaration text, which should communicate actions at a higher level, and meetings under the declaration should provide the agenda for work and broader frameworks of activities to be carried out under this declaration. So our suggested wording for 4.6 would be meet on a regular basis with states, the United Nations, the ICRC, and other international and civil society organizations to review the implementation of this declaration and identify any relevant additional measures that may need to be taken to improve compliance with international humanitarian law and strengthen the protection of civilians and civilian objects with regard to armed conflict involving the use of explosive weapons in populated areas. And lastly, 4.7 seems to be a good one with the additional text that would welcome and promote the effective implementation of this political declaration. Thank you very much.
Thank you to Norwegian People's Aid. I now give the floor to Spain to be followed by the Centre for Civilian Rights.
Muchas gracias.
Thank you very much. I would like to congratulate first and foremost both Ambassador Gaffey and you yourself on the inclusive and transparent way in which you are guiding this process and focus solely on 4.6, given the different prospects for the follow-up work after the signing of the declaration. I said already yesterday that there are various fora to strengthen the implementation of the WIPA declaration, but this would not be the most effective way of carrying out our work because it would mean financially a costly and unstructured process. I'm thinking of presidency, coordination, financing, and other issues. And the first sentence in 4.6 seems to refer to this kind of process. So what about the costs involved? Because we are being very generous in this process, allowing for interpretation, which unfortunately was a bit of a problem today when it came to the English channel. But in the paragraph, we talk about states and other qualified organizations, which might be a sort of an elite group. Perhaps that might not work. We cannot support this type of approach because it is neither sufficiently inclusive or transparent, and it could have a partial approach or a biased one. We already have a declaration aimed at the protection of civilians from the use of certain conventional weapons, and it would be a framework for ongoing discussions on the implementation of the declaration. Spain, therefore, supports working in the framework of that convention on conventional weapons with the ultimate objective of negotiating on a binding legal document which would explain the different options more legally that we could then strengthen the political declaration by using. Thank you.
I now have the Centre for Civilian Rights to be followed by the ICRC.
Thank you, Chairperson, and to the Irish delegation on your continued work on this vital topic. Ceasefire Centre for Civilian Rights believes that the current draft of the political declaration should be strengthened regarding both investigating and tracking civilian casualties and data collection on civilian harm. While paragraph 4.2 is the most important section of the declaration operationally for data collection and tracking civilian casualties, we believe it is important that calls for a transparent, accountable, and strong approach to these issues run throughout the declaration. For the sake of brevity, we have therefore collated our comments regarding this issue into one intervention. Ceasefire welcomes the acknowledgement of the importance of tracking civilian casualties and military operations in the preamble in section 1.6. However, we are concerned by the declaration's lack of a corresponding commitment to this in section 3. We join with groups such as INU and other civil society organisations in calling for this to be clarified in section 3. States should commit to investigating and tracking civilian harm in real time, including both casualties and harm to civilian objects. This would promote respect for the right of families to know the fate of their relatives, to enable states to better understand civilian harm, and to shape operational approaches and policy regarding the protection of civilians. As detailed in a new report on protecting civilians in siege warfare published by Ceasefire last week, civilians in populated areas under attack will often be driven underground, obscuring the visibility of civilians and making investigation even more vital in urban warfare and when explosive weapons are used in populated areas. Where there is a failure to investigate, civilian casualties may go unacknowledged and unrecorded. Ceasefire is also concerned in section 4 regarding data collection and civilian harm. While we welcome the commitment to collect, share, and make publicly available disaggregated data on the direct and reverberating effects on civilians, we have 4 main recommendations on data collection. Firstly, paragraph 4.2 retains the qualifier where feasible and appropriate. This caveat should be removed to reflect the strong imperative on states to collect data on civilian harm from explosive weapons. We believe it is vital, and we agree with Air Wars, that this imperative is strongly stated. Secondly, 4.2 should also clarify the type of data that should be included, including data on weapons type, incident locations, the circumstances under which weapons have been used, and information on explosive remnants of war. This would help monitor the differing impacts of explosive weapons and improve civilian protection mechanisms. Thirdly, the scope of the data collected needs to be expanded to include civilian objects such as civilian property and infrastructure. Damage to civilian objects is a significant part of reverberating effects of explosive weapons and should therefore be explicitly included. Finally, civilians on the ground provide an essential source of data that requires to be taken into account. This declaration should acknowledge the important contribution of local civil society organisations, sources to data collection on civilian harm. Ceasefire believes that these recommendations of committing to real-time investigation and tracking of civilian harm, expanding the scope of the data collected on civilian harm, and increasing data transparency would operationally strengthen the declaration. This would help promote compliance with international law and improve the protection of civilians. Thank you.
Thank you to the Ceasefire Centre for Civilian Rights. I now hand the floor to the ICRC, to be followed by Conflict and Environment Observatory. ICRC, you have the floor, please.
Thank you, Chair. We're pleased to see many of the commitments in this section strengthened, and the role of international organizations and civil society in the work that will follow the adoption of the political declaration clearly mentioned. To further strengthen the text, we have submitted language proposals on paragraphs 4.1 and 4.4. On paragraph 4.1, given the importance and prevalence of partnered military operations and of support relationships between third states and state or non-state parties to armed conflicts, we would like to reiterate our view that cooperation and assistance regarding the implementation of the policies and practices put in place pursuant to the political declaration should also take place in the context of partnered operations, as well as where a state provides support to a party to armed conflict. We strongly recommend the inclusion of such a commitment in the political declaration. To this end, we propose adding after relevant stakeholders the phrase including in the context of partnered military operations or where support is provided to a party to an armed conflict. On paragraph 4.4, we welcome this paragraph, which we see as significantly improved compared to the previous draft. While the term holistic attempts to capture the different types of assistance victims need, we reiterate our recommendation to add brief language specifying what victim assistance would consist in. For this purpose, we recommend adding at the end of the paragraph a new sentence that would read as follows. Victim assistance includes physical rehabilitation, psychosocial support, and socioeconomic reintegration. We are, of course, open to alternative formulations to the same effect. Lastly, allow me to react to some of the suggestions made so far on paragraphs 4.6 and 4.7. On paragraph 4.6, and in general, we strongly support the retention of a clear, unhindered role for international organizations and civil society in the follow-up to the political declaration, and we would caution against amendments that would water down or limit the scope of their involvement and participation. Military-to-military dialogue, including the exchange of good practices, is undoubtedly an important tool in advancing compliance with international humanitarian law and in operationalizing the commitments undertaken by means of this declaration. But the task of promoting full implementation of legal obligations and political commitments, and of identifying further measures needed to strengthen IHL compliance and the protection of civilians, cannot and should not, in our view, be left to militaries alone. The effective implementation of the declaration will largely benefit from the involvement of a variety of stakeholders beyond armed forces, notably civilian policymakers, humanitarian organizations, the wider civil society, and other subject matter experts. They can complement the military perspective by bringing to these discussions, notably the perspective of the civilians impacted by the use of explosive weapons in populated areas and how best their protection can be strengthened, which is at the core of this declaration. So paragraph 4.6, in our view, should make clear that work on the implementation of the declaration should take place in an open, inclusive, and transparent manner, the very elements that have marked this diplomatic process so far, and should be accessible to all states, both their military and civilian policymakers, and relevant stakeholders with an interest and expertise in furthering the goal of better protecting civilians against the effects of explosive weapons in populated areas. Finally, on paragraph 4.7, we welcome and support, on the same paragraph, 4.6, we welcome and support the proposal by Germany for discussions on the indirect effects of explosive weapons in populated areas, their scope, understanding, and measures to better integrate them in the planning and conduct of military operations in the context of the follow-up mechanism. We also support Germany's proposal to include language encouraging non-state armed groups to adhere to this declaration and to effectively implement the commitments it expresses, either in paragraph 4.7 or in paragraph 3.6, on which we have submitted a similar proposal that we will come back to when we discuss section 3. Thank you.
Thank you to the ICRC. I now give the floor to Conflict and Environment Observatory, to be followed by Wilf.
Thank you, Chair. In light of the comments made yesterday, urging states to ensure that the political declaration properly addresses environmental risks, I would like to make the following points on section 4. We believe it is particularly important to reference the environmental consequences of a WEPA in section 4 of the draft text on commitments on data, assistance, and follow-up measures. Affected communities can be better protected if environmental considerations are taken into account during response and recovery, and critical to support delivery of the Sustainable Development Goals. This includes implementing best practice in the assessment and sound environmental management of conflict debris and pollution. For our specific suggestions, amendments to include reference to the environment and environmental impacts in section 4.1, 4.2, 4.3, 4.5 and 4.6, I'll just refer you to our written submission. Thank you.
Thank you. I now give the floor to Wilf, to be followed by Project Ploughshares.
Thank you, Chair. WILP supports the comments on this revised text made by the International Network on Explosive Weapons, of which WILP is a member. As an organization, WILP has a few points to raise or amplify. 4.1 should urge international cooperation and assistance among all relevant stakeholders to exchange information and experiences in enhancing the protection of civilians, ending the use of a WIPA and preventing armed conflict. In 4.2, the reference to where feasible and appropriate should be removed in relation to collecting and sharing data. Data collection on civilian harm should be disaggregated by sex and gender, age, and disability. Data collection should also include recording of destruction and damage to civilian objects or infrastructure. As noted earlier, commitments on data collection in the declaration should call for the collection of data on types, locations, and effects of weapons used to be better tracked with weapon systems are causing harm. This could be included in 4.2 or 5.2 bis. 4.4 is much improved. It could be further strengthened by articulating what victim assistance includes, such as ensuring basic needs are met and safe and timely access to the provision of emergency medical care, physical rehabilitation, psychosocial support, and socioeconomic inclusion, as well as support towards the full realization of the rights and full participation of victims in societies. A further commitment in relation to humanitarian aid could be added in a 4.5 bis regarding the provisions and facilitation of safe, rapid, and unimpeded access for gender-sensitive humanitarian relief in line with international norms and standards for providing principled and inclusive humanitarian assistance based on the assessed needs of those affected. Such assistance should recognize and prioritize the involvement and leadership of women, LGBTQ+ people, people with disabilities, and others in marginalized positions in decision-making at all levels around the planning, delivery, and other management of humanitarian assistance. Thank you.
Thank you, Wilf. I now have Project Ploughshares, to be followed by Human Rights Watch.
Thank you, Chair. I am speaking on behalf of Project Ploughshares and of the CELAC Network on Human Security in Latin America and the Caribbean, both members of INU. This statement relates to Operative Section 4, in particular the need to establish a robust and effective institutional framework for the implementation of the political declaration. No matter how strong the final text of the political declaration may be on paper, it will only be as effective as implemented. We therefore encourage all stakeholders to ensure the establishment of a framework for implementation that has high standards of clarity, transparency, and regularity. The provisions in the draft political declaration related to data collection, data sharing, and best practice could benefit from further elaboration and precision. The declaration called for relevant data to be shared and made publicly available where feasible and appropriate. Under which circumstances would data not be made public? And where is such data to be shared? How? When? How often? Would there be a central repository? Consideration must be given to the possible institutional framework that will sustain this regime established around the political declaration. This would not just allow for assessing implementation progress and sharing relevant data, but would also provide continuity to this process, serve as a focal point for a community of practice, and promote universalization of the political declaration. How often will states meet? Where? Will there be a formal permanent secretariat? What are the financial implications? How will these be addressed? We urge all stakeholders to seek clarity around data sharing, appropriate forum, and frequency of gatherings, with a view to establishing an effective implementation regime. Finally, the focus of meetings should be on the humanitarian consequences arising from the use of explosive weapons in populated areas and on the specific measures being taken to implement the political declaration, not just to reiterate the need to comply with international humanitarian law, which is a pre-existing obligation that constitutes the minimum baseline for this process rather than its sole objective. Thank you.
Thank you. I now have Human Rights Watch on my list, to be followed by Humanity and Inclusion.
Thank you, Chairperson. We welcome the improvements to Section 4, particularly with regard to the victim assistance paragraph. But as with other sections of the draft declaration, we see several areas that should be strengthened. In paragraph 4.2 on data collection, we urge the removal of the caveat where feasible and appropriate, because it weakens the commitment to share data. As noted on the first day of consultations, transparency promotes understanding, accountability, and effective implementation of this declaration. We also recommend broadening the types of data collected and shared to include damage to civilian objects and details about the operational use of explosive weapons in populated areas, including the number and types of weapons used, locations targeted, and the circumstances of use. Such information can offer valuable lessons about how best to protect civilians, as well as inform efforts to respond to any harm caused, notably through explosive ordnance removal and risk education. Paragraph 4.4 on victim assistance has been significantly improved. The commitment to provide, facilitate, and support assistance is stronger than the previous version, and the understanding of victim is more comprehensive because it now includes, quote, those critically injured, survivors, families of those killed or injured, and communities affected. The paragraph, however, should be expanded to identify key forms of assistance, including the meeting of basic needs such as food, shelter, water, medical care, sanitation, and electricity, timely access to emergency medical care, physical rehabilitation, psychosocial support and measures for socioeconomic inclusion, and support towards the realization of victims' human rights. Next, we recommend adding a paragraph 4.4 bis that reinserts the commitment to, quote, provide and facilitate safe, rapid, and unimpeded access for humanitarian relief. Paragraph 2.3 recalls the existing international humanitarian law obligation to provide passage of humanitarian relief, but that paragraph is merely a preambular restatement of the law, and a commitment is required. In addition, access is a broader concept than passage, which typically refers to the delivery of assistance that has greater geographic and temporal constraints and is less sustained. We echo the comments made by other delegations this week in saying that a regular, robust follow-up mechanism is imperative if the promises made in this declaration are to have any effect. In light of the dedication seen in this room and the extensive civilian suffering we have all observed in recent months and years, work must begin as soon as possible. We urge states in paragraph 4.6 to set a deadline for the first follow-up meeting, along with a commitment to hold annual or biennial meetings. The paragraph should specify that those meetings are open to international organizations and civil society groups, thus maintaining the inclusive spirit in which the declaration has been negotiated. We also note that the proposed good practices working group mentioned in 4.6 should be a pursuit that is separate and distinct from these regular state meetings. Finally, we welcome the amendment to paragraph 4.7, which commits states to seek the declaration's, quote, adoption and effective implementation. In so doing, it emphasizes the need for states to operationalize the commitments in this declaration. Thank you.
Thank you, Human Rights Watch. And next on my list is Humanity and Inclusion, to be followed by Switzerland.
Thank you, Chairperson. We support commitments earlier provided by INU, specifically adding additional commitment on gathering data on the use of explosive weapons, including types, locations, and quantities used. Gathering and sharing such data would indeed assist humanitarian operators such as Humanity and Inclusion to rapidly provide explosive ordnance risk education or to rapidly plan explosive ordnance clearance activities. We fully support the text suggested by INU to avoid reading it again. Commitment 4.4, which is our favorite, and that's not a secret. We thank you for already strengthening it. But there is no such thing as too strong text on victim assistance or too wide group of people to assist. It is human suffering that is continuously gathering us. We have to make sure that we have a text that will prevent future civilian casualties and civilian harm, but also assist current victims. We expect the political declaration to establish an inclusive framework for implementation with clear commitments to assist victims. Echoing excellent comments from Germany, as well as INU and many other delegations, we believe VA commitment could benefit from additional improvements, not only stating that victim assistance is needed, but also sharing what victim assistance includes. So adding at the end, victim assistance include ensuring basic needs are met, the provision of emergency medical care, physical rehabilitation, psychosocial support, and socioeconomic inclusion, data collection, as well as support towards the full realization of the rights and full participation in their societies. We have also previously spoken how a strong standalone commitment on providing humanitarian assistance is needed in the operational section 4 of the political declaration, because the provision of humanitarian assistance in the EVIPA context entails many specific challenges. First, the challenge of access. Access to vital services such as emergency healthcare and basic humanitarian aid is challenged when impacted communities and humanitarian workers cannot leave or enter the zones which are being under attack with sufficient guarantees of security. Most persons with disabilities, older persons, children, persons with injuries are even more at risk. Protection of humanitarian workers is also a key issue, as well as capacity of humanitarian organizations to interact with armed actors controlling the concerned areas. Second, the challenge associated with the scale of needs. When whole cities are trapped under bombing and shelling with affected critical infrastructure, or when very high numbers of refugees or IDPs are arriving at the same time in areas or host communities often already destabilized by the conflict. And third, the need to adequately address specificities observed in the EVIPA context when designing the humanitarian response. First, the scope and severity of psychological harm and trauma and distress, as described earlier, the need to incorporate mine action related activities in the humanitarian response plans, including education to the risk posed by explosive weapons. This is why we believe a clear and strong standalone commitment on humanitarian access should be added in section 4 of the political declaration as follows. I quote, "Provide and facilitate safe, rapid and unimpeded access to principled and inclusive humanitarian access." I end quote. Thank you very much, Chairperson.
Thank you to Humanity and Inclusion. Next on my list is Switzerland, to be followed by Austria. Switzerland, you have the floor, please.
Thank you, Mr. Chair. Section 4 of the political declaration is paramount as it defines the follow-up process. Switzerland welcomes such an inclusive process as it will be useful to understand how the declaration is implemented and what its impact regarding the practice on the ground will be. We are open regarding the frequency of follow-up meetings, but deem the central provision contained in paragraph 4.6 integral to the declaration, as has been pointed out by other delegations today. Having said that, we propose some amendments to section 4 in its current form. Among those, I would like to highlight 3 in particular. First, the commitments listed in section 4 all cover important aspects. However, there seems to be a lack of clarity in some places. Some paragraphs would apply to all signatories of the declaration, for instance, paragraphs 4.1, 4.6, or 4.7. Other paragraphs concern only, or at least primarily, parties to conflict, such as 4.2 or 4.3. We are of the opinion that the declaration would benefit if this distinction is either captured in a chapeau or reflected in more precise textual elements in the paragraphs concerned. Second, we propose to take up 2 important points from the preamble into the operative section by adding 2 short paragraphs. In the first one, we suggest to include a commitment highlighting the importance of establishing the facts in cases of alleged violations. Paragraph 1.6 mentions the importance of investigating harm to civilians. We believe this should also be reflected in the operative part of the declaration. A possible paragraph 4.bis could thus read, and I quote, "In cases of allegations of violations of international humanitarian law, seek clarification and ensure that facts are established, including through fact-finding mechanisms," unquote. In a second separate paragraph, we suggest to take up the last sentences of paragraphs 1.6 and 2.1, where the importance of accountability is rightfully recognized. Ensuring accountability not only serves to punish those responsible for a violation, but also contributes to the acknowledgement of past violations and the prevention of further violations. Accountability is therefore a critical precondition to any sustainable transition to peace and stability. We believe it should therefore have a more prominent role in this declaration, including in its operative section. Our suggestion for a paragraph 4.2 ter reads as follows, and I quote, "Use domestic and international measures to hold to account those responsible for serious violations of international humanitarian law, and to collect, compile, retain, and preserve relevant information to support efforts to hold those responsible accountable," unquote. Mr. Chair, a third and final point that I would like to highlight concerns the scope of some of the formulations. As underlined in our initial statement yesterday, we deem it important that the declaration does not only focus on the use of explosive weapons, but also takes into account the broader challenges linked to conduct of hostilities in urban settings. Any follow-up mechanisms should therefore promote the exchange of good practices beyond the sole question of the use of explosive weapons in order to develop a comprehensive understanding of the impact of military operations in populated areas. We therefore propose some changes in paragraphs 4.3 and 4.5 in this regard, and will convey these proposals as others to you in writing. Thank you very much.
Thank you indeed, Switzerland. I now hand the floor to Austria, to be followed by Sweden.
Thank you, Mr. Chair. I think I can be very brief. As with Section 2, Austria is of the position that the revised draft of Section 4 significantly improved and just needs some finishing touches. I will speak on 2 paragraphs only. On 4.4, we welcome the strengthening of the para in the current version. Since the beginning of the process, we insisted that the political declaration should include a strong commitment of victim assistance. In the paragraph itself, we would suggest to add victims, in particular, as we think that a simple enumeration as it stands at the moment entails the danger of overlooking a specific group. So the paragraph would read, provide, facilitate and support assistance to victims, in particular people critically injured, survivors, families of people injured or killed, and communities affected, and so on. The idea of including a brief explanation of who victims are and then what this assistance should be was raised by several delegations before us, and I think some of these proposals should offer a wonderful solution to close this gap. On paragraph 4.6, and as others before us, we very much welcome the meaningful and inclusive follow-up process, and from an Austrian point of view, we just want to reiterate the importance of reflecting the inclusion of all relevant stakeholders in the final version of the paragraph. INU phrased it as not unnecessarily limiting approach, a notion that we can support. On the other paragraphs in this section, we will submit some minor textual comments in writing. I thank you.
Thank you, Austria. I now have Sweden next on my list, to be followed by Friends World Committee for Consultation.
Chair, and good morning, colleagues. We're a bit concerned that the language used in some paragraphs of the commitments in Section 4 could indicate to go beyond the scope of a political declaration, which by definition is not legally binding. For instance, in paragraph 4.6, the current wording commits states to meet on a regular basis to review the implementation of this declaration, which to us seem to be creating new obligations. We would prefer to reword the beginning of 4.6 to read, encourages states to meet on a regular basis to discuss and identify any relevant additional measures, and so on. Moving on to paragraph 4.7. In the same vein, the word implementation creates concern to us, since the paragraph in its current wording could be understood in different ways, whether it's interpreted as for states to only commit to certain policies, or that states are undertaking new obligations under IHL. So we therefore suggest to delete the words effective implementation from 4.7. Thank you, Chair.
Thank you, Sweden. I now hand the floor to Friends World Committee for consultation, to be followed by the Republic of Korea.
Thank you, Chair. In section 4.6, we raise that good practice needs to be clarified. Further, this paragraph could be strengthened by including references to other actors relevant to the aim of this paragraph. After the word good practice, it would read, which could form the basis for exchanges between humanitarian actors, structured military to military, civil society and other exchanges, workshops and seminars between all relevant stakeholders. Thank you.
Thank you. I now hand the floor to the Republic of Korea, to be followed by Civic.
Thank you, Chairperson. Just quick comments on paragraph 4.4 to echo the points made by Human Rights Watch and Sweden. My delegation wishes to delete critically in the first line out people critically injured. By doing so, we can avert interpretation that people with less critical injuries are excluded from the assistance from countries. And finally, with regard to the extension of data in paragraph 4.2, it should be balanced with military and security concern and requires further consideration. Thank you.
Thank you. I now hand the floor to Civic, to be followed by the Philippines.
Thank you, Chair. Civic would like to echo concerns raised this morning by delegations on suggestions that only indiscriminate use of explosive weapons is problematic. Narrowing the focus to indiscriminate use would undermine the value of this declaration, which not only reflects the humanitarian impact on civilians and civilian objects, but critically commitments to identify, implement, and share good practices to address risks associated with explosive weapons with wide area effects. Civic also supports recommendations by Germany to include language on non-state armed groups in section 4 and follow-on discussion on indirect effects of weapons. Specifically, Civic has comments on 4.1. We welcome language committing to strengthening international cooperation on good practices to enhance the protection of civilians, including with relevant stakeholders. Given the growing practice of military coalitions and security assistance to parties to a conflict, Civic reiterates our call that good practices and policies enacted pursuant to this declaration be shared in security assistance and partnered operations. We have seen all too often that when some militaries have enacted good policies and practices, these are not shared with partner forces, thereby missing a critical opportunity to minimize civilian harm by such forces. In section 4.2, we recommend adding language on collecting data on the impact of civilian objects to have a comprehensive analysis on civilian harm in order to improve military tactics, techniques, and procedures, and support for follow-on measures such as restoration of essential services and reconstructive initiatives. We also recommend adding language to record the location of use of explosive weapons to better support the work of organizations involved in mine clearance and risk awareness activities. In 4.4, we welcome the improvement of this paragraph and are encouraged by the more comprehensive understanding of victim. We, however, recommend adding age as a consideration along with gender and disabilities for consideration in victim assistance programs. Civic reiterates its recommendation to add types of victim assistance as recognized in landmines and cluster munitions framework. Thank you.
Thank you. I now hand the floor to Philippines to be followed by the United Kingdom.
Mr. Chair, the Philippines' engagement in humanitarian disarmament is rooted in the twin principles of victim centrality and strong national capacities. We are therefore delighted to see strong commitments for victim assistance in this section. We believe that language could still be improved with a view to ensuring that victim assistance includes ensuring basic needs are met, the provision of medical care, physical rehabilitation, psychosocial support, and socio-economic reintegration, as well as support towards full realization of rights and full participation of victims in societies. Further, this section should include commitments for the provision of full humanitarian access, particularly the facilitation of safe, rapid, and unimpeded access for humanitarian relief in accordance with international norms and standards. Finally, we support the recognition of gender differentiated impact of humanitarian consequences arising from IWIPA, which requires gender differentiated response. Thank you.
Thank you, Philippines. I now hand the floor to the United Kingdom to be followed by the Danish Refugee Council.
Thank you, Chairman. I'd like to make one broad point and then two on paragraphs 4.2 and 4.6. Let me start by reaffirming that this declaration and what it stands for is extremely important. But equally, if not more important, is what comes after. A text alone cannot improve the protection of civilians or reduce harm to civilians. It is a lever to do this. The follow-on process is where best practice can be shared, policies and procedures improved, and compliance with IHL promoted. The UK wants to be involved in this follow-on process. We believe we have insights and experience that would bring real value. That is exactly why this section is so important. So it's appropriate that we give it proper focus. I'll come back to this point with my comments on paragraph 4.6. On the specifics of paragraph 4.2, let me be clear that tracking civilian harm is extremely important. Not only is it necessary to determine if processes can be improved and to better understand indirect effects, but we also have a moral obligation to do it. However, two changes to this paragraph are required to ensure that any obligation or commitment is an appropriate and realistic one, and that all parties are clear about what it entails. We previously raised points on the use of the term reverberating effects in this context. We acknowledge the significant amount of work on the concept and the varying views of delegations here. But as it isn't an internationally recognized term, what's meant by it, and therefore what this obligation covers, isn't understood. Its scope is therefore unclear as it stands. We don't dispute the significant and long-lasting impacts that arise out of the use of explosive weapons, but an obligation to track effects that aren't fully clarified, accepted, or are unclear would be fraught with difficulty and place unworkable burdens on parties to armed conflict. The term indirect is therefore better suited and bounds the obligation more clearly. The current wording also doesn't fully capture the limitations on the capability of those actively engaging in live hostilities to get the full picture. So there needs to be acknowledgement of what is actually feasible, and feasibility is relative to the situation. Recognition that more reliable data comes through working with the UN and others, as is highlighted in 4.3, could also come through more strongly. There's also a separate point on the collection of data. Separate regulations govern what can and cannot be collected, retained, or shared. And we must ensure that any text does not create obligations that could fall foul of these. Three changes are therefore required to the paragraph. A switch at the beginning of the paragraph so that it reads, where feasible and appropriate, collect and share. Replacing reverberating with indirect, and the amendment of military operations with armed conflict, as French colleagues have suggested. As a whole, the paragraph would read, where feasible and appropriate, collect and share and make publicly available disaggregated data on the direct and indirect effects on civilians of armed conflict involving the use of explosive weapons in populated areas. These changes don't seek to absolve states of the responsibility to track or share data, but do ensure that the obligation is grounded in practicality and has a sense of what is possible in real-world situations. Moving now to paragraph 4.6. As I mentioned at the beginning of this intervention, this is where tangible improvements can be made to the protection of civilians. It's true that we need some sort of mechanism to hold each other to the standards we're setting ourselves in this declaration, but it needs to be more than that too. It needs to ensure that compliance with IHL is genuinely promoted, that best practices are shared, and that the impacts of this feed through into real-world situations. It should be balanced to ensure that most value is gained without creating too extensive a burden. We're also clear that some conversations are appropriate on a state-to-state level, but that civil society and institutions like the UN or ICRC have huge value to add in others. We share the views of our German colleagues on the potential benefit of discussions on best practice to measure indirect effects, and believe that the paragraph might also benefit from some wording about what a framework for the sharing of best practice on policies and practices might look like. Such wording shouldn't be extensive or too prescriptive, but setting out a little more clearly how this process can work could be helpful to ensure that all parties are clear about what next steps look like. Thank you, Mr. Chair.
Thank you. I now hand the floor to Danish Refugee Council to be followed by the United States.
Thank you, Ambassador. As an organization committed to tackling systemic inequality and structural discrimination against conflict and displacement affected persons, we deem it imperative that Section 4 include clear commitments to ensure people and communities affected by explosive weapons in populated areas are able to seek safety and claim basic rights, as well as pursue self-reliance. We welcome the additions made to Article 4.2, which includes the need for data collection and public dissemination. However, we'd like to see this article remove the caveat of where feasible and appropriate, and to be expanded to specify the types, numbers, and location of explosive weapons used in order to allow for effective and unhindered humanitarian response. We therefore would like to propose the additional wording of Article 4.2 to include collect and record the location of areas targeted using explosive weapons, including the appropriate number of explosive weapons used and the general location of known and probable unexploded ordnance as presented by INU. We similarly welcome the significant improvement of Article 4.4, which now clearly states the commitment to provide, facilitate, and support assistance to people critically injured, survivors, and affected communities. However, we see an opportunity to further strengthen this article by clarifying the breadth of victim assistance. We therefore suggest adding the following wording to the current text of Article 4.4. Victim assistance includes ensuring basic needs are met and safe and timely access to the provision of emergency medical care, physical rehabilitation, psychosocial support, and socioeconomic inclusion, as well as support towards the full realization of the rights and full participation of victims in society. In this section, it will be equally important to add a clear commitments towards ensuring rapid, unhindered, and principled humanitarian access to those and for those affected by the conflict, to enable the protection of the rights and meet the needs of the civilian population, regardless of their gender, age, disability, place of residence, ethnicity, and nationality without discrimination. This means supporting efforts to ensure timely, safe humanitarian corridors, commence, sustain, and enhance the provision of humanitarian aid and protection services, as well as the establishment of operational mechanisms to support humanitarian actors through supply lines and capacity building, and a lift in the administrative impediments. Therefore, we join our INU colleagues and urge you to include a strengthened provision on supporting humanitarian relief and access, in line with the proposal made by the network. These additional statements of wording will, of course, be shared with the chair accordingly. Thank you.
Thank you. I now hand the floor to the United States to be followed by Belgium.
Thank you very much, Mr. Chair. I think we've had a very good debate this morning. And I think all the speakers have noted just how important it is to get these provisions in Section 4 right, because the real world effect of this declaration will come in how we collectively move forward. Let me start with Section 4.2. I think we would caution against those delegations who would have us remove what they called caveats. I think the UK has stated very effectively how important it is to be realistic here in this important provision related to collecting and making available data. As we've already discussed at length, and again, here we would agree with what the UK has already said. It's important for Section 4.2 not to call for data on reverberating effects. States have to know what they're committing to collect data on. Reverberating effects is not defined or understood. It would make a difference to replace the word reverberating with indirect so that we could accomplish the goal of the section without the use of a novel and undefined term. With respect to Section 4.4, we would note that in the current draft, the beginning reference to assistance was changed from make every effort to assist victims, which we found to be perfectly direct and appropriate, to provide, facilitate, and support assistance to the injured survivors, families, and communities affected by armed conflict. This change significantly expands the scope of the commitment of states that states would have to undertake in this section. The United States is absolutely committed to providing assistance for individuals and communities affected by armed conflict, and we already provide a significant amount of such assistance for these purposes. However, as redrafted, the commitment is unrealistically too broad, and we expect that other states may also not be in a position to make sort of an undefined financial commitment here. And I think we've already heard some of those red flags this morning. At the same time, we acknowledge that for some, the prior language, make every effort, was seen as a little bit too weak. So our proposal is to change provide, facilitate, and support, meaning you'd have to do all three, to provide, facilitate, or support assistance. This would maintain the thrust of the section, but would recognize that states will make the type of contribution to which they are able, and which may not in all cases be monetary. Let me now turn to the follow-on mechanism, which is, I think, as some have already said, the critically important part of this declaration to its real-world impact. The United States believes that this declaration should establish a positive, collaborative way forward for follow-up that focuses on voluntary military-to-military exchanges of technical expertise and good practices to improve compliance with IHL and efforts to mitigate civilian harm. We cannot agree to a forum that would judge states' compliance with the declaration or engaged in the politicized criticism of states' conduct on the battlefield. As some delegations may recall, the principles of non-politicization and non-contextualization were universally endorsed. I think Israel's already mentioned this in a process that went on for many years here in Geneva, and finally gave birth to a Swiss ICRC initiative on strengthening respect for IHL. And these safeguard principles are critical to ensure that we have a process, a forum, where states, military experts can share their good practices without getting bogged down in political debates. Israel's proposal to incorporate specifically some of these safeguards against politicization. These things that we very painstakingly negotiated over many years is a very good one, and it could be refused. It would be useful to reflect some of them here. We've already seen the value of those safeguards in the initial meeting that the Swiss had convened, and I know there was another one that was proposed for May, which has now been delayed. I think all of our intention here is for 4.6 to give us an idea of what this follow-on mechanism should be. And we think that 4.6 needs to be edited to reflect the kind of approach that is possible here. Specifically, we should say that the follow-up on this declaration would be, and I quote, "Through the exchange of good practices and lessons learned." We think it's important to add that language. The current reference, which is to, quote, "regular review of implementation," has been already criticized this morning as not appropriate for a non-legally binding instrument, and we agree wholeheartedly with that point. In addition, while our delegation places great value on the input of the UN and its bodies, the ICRC, to other international organizations and civil society organizations, such as those we have here, and we see a very useful role for them in future follow-up to the declaration, the focus still has to be on states. Thus, where the declaration calls for the development of a compilation of good practices to form the basis of structured military-to-military exchanges, we think this should be developed by states with input from interested organizations. We therefore recommend clarifying that interested states would, quote, "with input," unquote, from the UN, the ICRC, and others, would implement or carry out the follow-up to this declaration. I think in this respect, we would disagree with Human Rights Watch, for example, that we should have two processes, one for the military exchanges and one for some politicized or potentially what could end up a politicized debate. I don't think we see that is the recommended outcome. We would also note that at least one delegation suggested that maybe we should go to the CCW to work on a binding instrument. I don't think that should be something that would be in this declaration. The CCW itself could take up projects as it sees fit. Finally, Mr. Chair, and hopefully to be very practical and helpful, I'd like to, with your indulgence, ask one of my colleagues from the Department of Defense to talk a little bit about existing programs that the U.S. government has for addressing civilian harm and for coordinating with our partners and other states, and also with outside entities on how to improve practices related to the protection of civilians in armed conflict. And what I hope, Mr. Chairman, is that in describing some of these projects and programs, that we could not only provide information for delegates, but also perhaps provide some inspiration for what a very effective follow-on process could be for this delegation. So with that, Mr. Chairman, I would turn it over to my colleague here. Thank you.
The United States is already engaged in a number of practices to collaborate with our allies and partners around the world on supporting and improving their efforts to mitigate and respond to civilian harm in their operations. In 2016, the US president at the time issued an executive order that provided that US executive branch departments, such as the US Department of Defense, to engage with foreign partners to share and learn best practices for reducing the likelihood and responding to civilian casualties, including through training and assistance. US law over the years has also provided the US Department of Defense the authority and direction to take a number of actions, including to through the use of capacity building programs, improve the ability of foreign national security forces to better protect civilians, integrate the protection of civilians into U.S. security cooperation, assessment, monitoring, and evaluation programs with respect to foreign forces, and provide authority to conduct legal institutional capacity building for these foreign forces with the purpose of, among other things, provide for the protection of civilians consistent with the law of armed conflict, and to ensure good procedures for the investigations of incidents from their operations that may have resulted in civilian casualties. We've hired subject matter experts to lead these specific efforts. The U.S. State Department and the U.S. Department of Defense also regularly engage with NGOs interested in civilian protection issues and have taken their feedback into consideration in the development of our efforts. For example, the U.S. Department of Defense is developing a series of training materials intended for different positions and levels in foreign partners' militaries, with content that ranges from improving understanding about risk related to protecting civilians in armed conflict, employing weapons, developing rules of engagement, to using accountability mechanisms. Operationalizing the law on civilian harm mitigation means this training not only introduces and reinforces existing awareness of measures that help mitigate civilian harm, but also the importance of commanders' intent and ethical leadership in carrying out these efforts. This contributes to partners developing a strong culture around the protection of civilians, promoting their thinking strategically about civilian harm issues, and testing hands-on applications within militaries to provide for better protection for civilians. In addition to training, we are also integrating civilian harm mitigation into our advisory efforts and have begun doing so in areas such as the use of intelligence, surveillance, and reconnaissance, and targeting by foreign countries' militaries. NGOs and civil society organizations have provided feedback on the scope of materials and the learning objectives, as well as shared their own materials and insights for integration to improve our efforts. We also have a line of effort around providing specific technical tools, data, and training on targeting, as well as on the U.S. collateral damage estimation methodology, which has been adopted by NATO. We've ensured that we have the software, data, and technical training courses that can be readily shared with our partners. We've also chartered independent studies and conducted a number of internal studies on our own civilian harm policies and procedures. Most recently, the U.S. Secretary of Defense issued a memorandum in which he reaffirmed our firm commitment to international humanitarian law and noted that the protection of civilians is fundamentally consistent with the effective, efficient, and decisive use of force, and our efforts to mitigate and respond to civilian harm are a direct reflection of U.S. values. It is a strategic and moral imperative. The Secretary of Defense also directed the development of an action plan to implement recommendations from completed studies, evaluations, and independent reviews. The action plan is currently being developed, and as a result, the U.S. Department of Defense will be establishing a civilian protection center of excellence to better expedite and institutionalize the advancement of our knowledge, practices, and tools for preventing, mitigating, and responding to civilian harm. We are eager to collaborate with other countries on the implementation of the political declaration once signed, including through the continued compiling and sharing of good practices, and look forward to discussing the possible exchanges, workshops, and exercises we could leverage to do so.
Thank you to the United States. Next on my list is Belgium, to be followed by Uruguay.
Mr. Chairman, I have two quick comments regarding paragraph 4.2 of the text. First, I would like to draw the attention of this delegation statement of yesterday, in which we requested to replace the notion of reverberating effects by indirect effects or incidental effects, as reverberating effects is not a legal existing concept under IHL. And then second, still concerning paragraph 4.2, as non-native speakers, we'd be more information would be welcome on the replacement of the word possible by feasible. Thank you.
Thank you, Belgium. I now hand the floor to Uruguay, to be followed by Ocha.
Muchas gracias. Thank you very much for giving me the floor. As we said yesterday, Uruguay would like to remind you that it thinks it is relevant in section 4 to give more details on possible assistance that could be given to civilians if weapons are used. So in Spanish, we would propose that this assistance should consist of emergency medical care, physical and social care, and measures to promote family reunification, protection of children, women, and minority and vulnerable groups for their social reintegration and other possible measures. So we support, in this connection, the proposal put forward a moment ago by the Philippines. And our text in English would be as follows.
Al final de 4.4.
At the end of 4.4.
Such assistance could take the form of emergency medical assistance, physical and psychological rehabilitation, measures to promote family reunification and childhood protection, protection to women and girls and other minority vulnerable groups for social reinsertion. Muchas gracias.
Thank you very much.
Thank you to Uruguay. I now have Austria on the floor to give the floor to be followed by Canada, please.
Thank you very much for letting Austria take the floor. In line with the UN interagency comments that we have submitted to you, we would like to thank you for the revisions made to Section 4 of the current draft. I would like to make one general statement and flag two specific suggestions for revision in this Section 4. We welcome the inclusion of the elements relating to data collection, victim assistance, clearance of explosive ordnance, and the general support to the work of the United Nations and other organizations in addressing the humanitarian impact and consequences of the use of explosive weapons in populated areas. The follow-up mechanism foreseen in the declaration is an important element that we will look forward to contributing actively towards, notably in sharing good practice and facilitating that exchange. We believe that this mechanism will benefit from the implication and involvement of both civilian and military participants. With respect to the specific suggestions we would like to make, for paragraph 4.3, we would suggest that the caveat "as appropriate" be removed as a consequence of change in the word from support to facilitate in the current draft. For paragraph 4.5, refers to the general provision of humanitarian assistance in response to the humanitarian consequences arising from the use of EWIPA. Here we would also like to suggest the removal of the caveat "as appropriate," given existing legal obligations to allow and facilitate humanitarian access. Thank you.
Thank you very much. I have 4 more speakers on my list at the moment. Canada is next, to be followed by the Netherlands, Chile, Mexico, and the Holy See. So if anyone else wishes to take the floor on this section, please raise the flag. Thank you. I now hand the floor to Canada.
Merci, Monsieur le Président.
Thank you, Chair. Chair, as we've already said, our delegation intends to provide more detailed written comments, but for the time being, we will address 2 paragraphs in Section 4. First of all, paragraph 4.4 deals with an essential issue, that of assistance to persons affected by armed conflicts. We think it is vital to make every feasible effort to provide this assistance, but we must at the same time remain fully aware of the fact that this is not always possible. Along these lines, we propose that we amend the beginning of paragraph 4.4 by adding the words in English, "make every feasible effort to," before the word "provide," and then the paragraph would continue as proposed. In addition, we welcome the inclusion in this paragraph of the terms gender sensitive and non-discriminatory. With the amendment we have proposed to the first sentence, these qualifiers are totally appropriate in our view. Next, paragraph 4.6 outlines the foundations of a follow-up process. We would like to support this process, but it must be clear that its objective will be to exchange best practices in the framework of whatever declaration is adopted. it is our view that such a process should in particular act as a platform for discussions among military personnel on questions related to urban war and the protection of civilians. Therefore, it is essential for this process not to give rise to politicized discussions on compliance with international humanitarian law. We must bear in mind the fact that depoliticizing and strengthening the implementation of international humanitarian law go hand in hand. In this connection, the statements by the United States and France, we thought were extremely useful and we can support them. Thank you very much.
Thank you, Canada. I now hand the floor to the Netherlands, to be followed by Chile.
Thank you, Mr. Chair, for giving me the floor, and allow me to start by complimenting your delegation on this section. In broad terms, we're very happy with how the section is drawn up. However, we do like to make some specific comments on two paragraphs. Turning to section 4.2, which sets a commitment to collect and share data on the direct and indirect or reverberating effects on civilians of military operations involving the use of explosive weapons. As some other delegations have raised, my delegation has some practical concerns to the extent such an undertaking is feasible, given that access to certain areas that have been attacked may not be possible in many cases, making the collection of data for us an impossible feat. Taking into account these operational circumstances is important, I think, in this political declaration to have a real effect. And allow me also to note here that many of the active military states participating actively in this negotiation have raised this issue. Therefore, we suggest the start of paragraph 4.2 should read as follows: where feasible and appropriate, collect, share, and make publicly available disaggregated data, etc. Also in this paragraph, allow me to lend support to the proposal made by France and supported by the United Kingdom to change the term military operations with the term armed conflict. Turning to section 4.6, we share the view that the topic of the use of explosive weapons in populated areas is an ongoing discussion, also after this process here has been concluded with the adoption of a political declaration. Therefore, we recognize the importance of practical implementation of the political declaration and the contribution that the sharing of policies and good practices can make to that. At the same time, we have sympathy for those delegations who have raised questions on the establishment of a new forum for a follow-up process, its format, funding, and mandate. In our view, the exchange of policies and good practice on a voluntary basis by interested states should be the starting point. And in this context, we would like to note that many of the military active states here in this room already do this. Thank you, Mr. Chair.
Thank you to the Netherlands. I recognize we've reached the limit of our time available to us for this morning's session. So I recommend we come back after lunch, a well-deserved lunch after such a very useful and fruitful exchange of views, both on the end of section 2 and on section 4. And we will resume at 3 p.m. sharp with Chile, Mexico to take the floor, to be followed by the Holy See. Thank you very much.